Welcome to Legal Listening, where audio obiter is our thing. We're Carly and Zach, and we're so glad you're here with us today.
So today on the podcast, we have the Queen and Sledz, which came to me as a recommendation from Chad on Twitter. And the Queen and Sledz, it's a little bit different than what we've normally covered. It's not a Supreme Court of Canada case. It's not even an Ontario Court of Appeal case. It's a lower Ontario court decision of the Gladue courts out in Toronto. And just so if anyone's unaware, Gladue courts are specialized courts set up in Toronto in particular at Old City Hall that specialize in dealing with Indigenous offenders. So the thing with Sledz, I'll just kind of give the highlight reel. Sledz deals with whether Gladue factors are applicable at the bail stage for an Indigenous accused.
Yeah, so I was saying before we started recording, I think I read this in criminal procedure because we sort of got into whether, because obviously Gladue is codified in the code under 718. So we sort of got into whether applying these factors is considered appropriate at the bail stage, or if sort of taking general judicial notice about colonization is sort of a more prudent way of approaching it. Because obviously, you know, we know from Gladue and Ipeely that you need to be considering, like, the decider can take judicial notice of colonization every time before an Indigenous person is before the court. But we were sort of getting into the nitty-gritty over whether applying sort of specific things you might apply on sentencing may not be as appropriate in the bail setting. So quite frankly, I honestly don't remember the outcome of our discussion. I think we were sort of generally undecided, but that's the only context in which I've actually ever read this case.
Yeah, and I think that discussion, it's just a function of discussing like colonial law and Indigenous offenders, and I think that's kind of an unfortunate because we have effectively the colonial system overlaid on top of Indigenous offenders. And I mean, you could look at Gladue, you could look at Ipeely, you could look at the TRC. Mm-hmm. There are reports and commissions that all speak to the over-incarceration of Indigenous individuals. And I think this case, take from it what you will, but I think one of the important through lines is the justice acknowledges that there are too many Indigenous individuals who are incarcerated. Mm-hmm. And it happens both at the sentencing stage and, more importantly, at the bail stage as well, because they don't necessarily have the same advantages that the rest of the public has access to in terms of housing and sureties. And a lot of this flows from the way the Indian Act operates, mm-hmm. and a lot of systemic factors in dealing with Indigenous individuals and their communities. So I think in one aspect, it kind of assists the court in painting a certain picture of the accused, but at the same time, I do think there are some very valid concerns and valid critiques of this decision as well.
Yeah, no, it's a mixed bag decision in my opinion, but, you know, I think the justice in question is definitely not acting with any sort of malice. I think he really is trying to push the law forward because he's recognizing that there is, you know, a horrifying over-representation of Indigenous people incarcerated in this country. And the thing you were saying about, you know, sureties and stuff, it always strikes me how many of the things which create disparities in the law on the face of it don't seem strange. But then you realize sort of what these things can do when applied to hundreds of years of government policy of purposeful inequality, right? So it's like when you treat people who have been historically treated very unequally equally by saying sureties apply in this blanket way, it's going to disadvantage people who have been treated so unequally and unfairly and horrifically in the past, right? So it's almost like sometimes the most damaging things about the law can be things that don't look strange on the face of it and just seem like, you know, nitty-gritty, benign procedural things. And they can cause terrible, you know, effects.
Yeah, and that's exactly kind of what this case gets at. I think there's a lot of very valid concerns to be raised, not just about Indigenous individuals in the bail system and the criminal law system, but I think there are also some valid concerns out there about the way the bail system operates today. I know there are different people working on different projects, so if anyone happens to know any of them, please feel free to tweet at us, and we'll be glad to retweet out. We love to share legal information. That's what we're here for. So anyways, I hope you guys enjoy this one. The Queen and Sledz. Before Justice Nakatsuru, heard on March 8th, 2017. Reasons for the judgment were released on March 13th, 2017. Mr. Sledz is a Mohawk accused. He is facing some very serious charges. Along with 2 other men, he is alleged to have committed a gang sexual assault on a young woman late at night in downtown Toronto. Mr. Sledz has spent many months in jail waiting for his trial. On March 8, 2017, I was sitting in Gladue court. I released him on his own bail. At the time, I told you, Mr. Sledz, I would write this decision to explain more fully why I did this. I also hope this decision will explain to others why I believe your unique background as an Indigenous accused made this the right thing to do. Before I do, I need to point out that there is no ban on the publication of the evidence heard at this bail hearing. No one asked for one. I did not make one. However, you and your co-accused have not yet had your trial. Therefore, I will not say anything in this decision that might prejudice your right to a fair trial. I will also say nothing that might identify the young woman. First of all, I will talk about how you got to this bail hearing. It is different from the usual case. Right now, you and one of your co-accused are in the middle of your preliminary inquiry. The other co-accused, who was arrested months before you, is set to face his trial before a judge and jury in May. The Crown intends to join all of you together at this trial when you are committed to stand trial at your preliminary inquiry. As I understand from your lawyer, your defense will be an alibi. You have only asked for bail now. Within the past month, both your co-accused have received bail. I will say more of this later. Your lawyer argues that it would be unfair to keep you in jail while your co-accused have gotten bail. The onus is on the Crown to show why you must be detained in custody. She argues your detention is necessary for the protection and the safety of the public and to maintain confidence in the administration of justice. You testified at this bail hearing. I learned more about who you are. You are 33 years old, single. You have a difficult past. I will just say that you have a long history that is very relevant for a bail hearing. I will not say more about this for the reasons I have given before. The Crown naturally focused on this. The Crown also focused on the need to protect the young woman from you. Your father is Polish. Your mother was Mohawk. She died while giving birth to you. You do not have any brothers or sisters. From birth, you lived in an orphanage for 9 years, then placed in a number of foster homes. You were adopted by a Polish couple, but you returned to CAS care. You only met your father a couple of times, when you were an adult. They were hard meetings. You have described him as a racist. It is clear to me that there is no relationship between you and him. I am not sure there ever will be. It is at one of those meetings your father told you about your Indigenous background. It explains your dark complexion. It explains why your face looks the way it does. Since then, you say you have found some aunts from your mother's family, but you are not ready to contact them yet. I can understand that. You get Ontario Disability Support Program payments for anxiety and depression. You have an apartment that the program pays the rent. You are not sure whether you still have that place. You hope you do. That is where you plan to return when released. You have issues. Any treatment or help you have gotten has not been a complete success. The plan your lawyer has given me is a Toronto bail program release. In other words, you would be released on your own bail, with the Toronto bail program supervising and helping you. You have no one to act as a surety. Given your past, I can understand why you have no one in the world to come forward for you. It is sad, but it is your reality. I don't know much about you, but I get it. I get why you have no one willing to take on that job for you. Perhaps there would have been before, but not now. Your co-accused had very different bail hearings. Although the Crown argued against the release, they got it. I think this was because of the people who came forward for them. For one, his parents came forward. For the first time, this co-accused went to them with a changed attitude. He asked for their help. The family got on board. He was released to them under tight conditions, including only being out in their direct company. Even then, the Crown reviewed the decision to release him. The Superior Court rejected the Crown review. It agreed with the decision to release. Your other co-accused mother and aunt came forward. The aunt had a solid public service job. He was released on a house arrest bail, but the mother and aunt pulled the bail. This co-accused had gone to the gym without telling his sureties. However, the mother and aunt agreed to act again after a number of months served in pretrial custody. They were back on board, and he got released again, even though the Crown argued against his release. Your situation, Mr. Sledz, is different. Due to your life circumstances, there was no one on board for you. You are taking this journey alone. That is the key difference between you and your co-accused. The crimes you are alleged to have committed are the same. You all share similar backgrounds in a certain relevant way. Indeed, one of your co-accused, who is alleged to have taken a greater role in the gang sexual assault, has a background that is even more relevant than yours. The evidence against you and your co-accused is similar. Indeed, for one co-accused, it is stronger. When I look at this case, I am struck by this key difference. Your co-accused have people. They are out on bail. There is no one for you. You remain in jail. Now, Mr. Sledz, in bail cases, sometimes this happens. A person has no surety. This can be important in deciding if I can make a release order. If the only way I can be satisfied that the test for bail is met and that there is a surety, then there can only be one right decision. No surety, no bail. It does not matter whether the accused is Indigenous or not. But when an accused is Indigenous, I must think carefully about what having no surety available means to my decision. I have no doubt that your childhood has led to where you are now in life. You had no stability. You were taunted. You were subject to racism. You had no true identity of who you were. No doubt there were some good and kind people who did their best for you, but I think you did not receive the love and nurturing needed. To grow up straight, to have good people in your life, who took the time, who meant something to you, then and now. As an Indigenous person, you share a history, a common history with others, a history of being here on this land before the settler, a history of broken promises, of illness and death, the loss of land, the indignity of colonization. Then there is the history of some deliberate state policies that tried to commit cultural genocide of Indigenous peoples. Said crudely but accurately, policies that tried to kill the Indian and the Indian. As Canadians, we are all becoming more knowledgeable and sensitive to this history, and what it means. This common history sometimes has greater meaning when it comes to the personal history of someone like you. That history has led to too many children in care of the state. Too many children divorced from their Indigenous identity. Too many children who find themselves going from care to crime. Some of those children grow up to be adults who live at the margins of society, in poverty, without much opportunity or connection. They are not embraced by the community. They do not have the friends and the family that the luckier of us take for granted. These are the friends and the family that can come forward to help, like when you are accused of a serious criminal offense. This is you, Mr. Sledz. There is a disproportionate number of Indigenous persons in jail. That means, sir, that too many Indigenous persons, compared to their overall population in this country, find themselves behind bars. Too often this starts at the pretrial stage where they cannot get bail. Finding a solution means we must start at the bail stage. We must look at each case. We must carefully look at the unique situation of each Indigenous person, and we must try to find an answer. Even when that answer is hard to find, just as a surety may be hard for you to find. In this case, the difference between you and your co-accused is stark. They have a family. You do not. Their family bailed them out. No one is here for you. They are out. You are in. So when I look at your case and I ask myself whether detention is the only answer, I must be mindful that I do not want to become part of the problem. Of course, it would be perfect if you had perfect sureties, but I believe there is a way you can be safely released. You and the young women do not know each other. There was a period of some 7 months after the alleged attack and before you were identified and arrested that you were out, free in the city. At no point during this time did you bother this woman or try to seek her out, let alone cause her any harm. There is nothing in your personal history related to this type of alleged sexual offense. No one suggests that you are some form of serial sexual predator. The Toronto Bail Program is willing to supervise you. They will offer you help as well. You will only be on bail for 3 months before you face trial along with your co-accused. Your Indigenous identity has meaningfully contributed to the situation where you have no surety. No one stands beside you. Given all this, I find that the Crown has not shown why you must be detained. The Crown has not shown it be necessary for the safety and protection of the community. To give you this release will further the goal of solving the evil that is the over-incarceration of Indigenous people without sacrificing the goals of the bail law. The final test is whether the Crown has shown your detention is necessary for the public confidence in the administration of justice. This is a test that sounds very lawyerly. I don't need to explain it any further to you. This is because your co-accused met this test. They are the same as you in many ways. The co-accused met this test even though his situation in some ways was worse than you. That person's bail was confirmed by a higher judge than me. I find that the Crown has not shown why you must be detained for this reason. So, Mr. Sledz, I released you on your own bail with the Toronto Bail Program watching you and with some tight conditions, including a curfew. I hope this written decision sheds more light into why. I hope this decision also tells others why, in some cases, the Indigenous accused must be treated differently than the other non-Indigenous accused. I believe this is the right thing to do.
Legal Listening is founded by Zach Battiston and Carly Lyons. Hosted by Zach Battiston, Carly Lyons, and you, our listeners. Executive produced by Zach Battiston, Carly Lyons, and Anthony Radamile. Audio engineering by Anthony Radamile. Graphic design by Julie Lundy at julielundyart.com. Music by Matt Radamile at radandkel.com. We're always open to ideas, suggestions, and of course guest readers. Check us out at Legal Listening on Twitter and at legallistening.com. We'll talk to you next time.